When we call in Prime Creator, we are tapping into our essence, our inherent God fractal. It is that which supports us whether we pay attention or not, but greater is the flow and ease of our righteous activity when consciously aware of Source, as if we are riding on your wings. May we be graced today and all our days going forward in all that we do, in your name, and so it is. I'm reading an instrument that we have put forth and mailed to entities, Mike Reese, Director, Oregon Department of Corrections, Ken Jeske, Deputy Director, and to Corey Fury, Superintendent of OSP. Also to Governor Tina Kotek, to Deputy Secretary of State Cheryl Myers, and numerous others in our governance. This is a notice of intention to commence a proceeding. It is cause number 07272024-DAC-intent. Notice to principal is notice to agent. Notice to agent is notice to principal. On July 9th, 2024 AD, 8 members of our Civilian Common Law Court of Record made significant efforts to deliver a writ of habeas corpus ad subjudiendum to the Director of Corrections, Mike Reese, at his office. Our contingent then traveled to OSP to deliver the same document. That's the Oregon State Penitentiary. The purpose was to extricate David Anthony Coolidge back into his proper jurisdiction and to our court for a lawful grand jury hearing with complete evidence, not parsed and skewed, as in the de facto grand jury and fraudulent trial, rife with unlawful and illegitimate procedures and processes. All the while, David Coolidge was trespassed, jailed, ankle monitored for months. He was lawfully pleading his innocence, and that he was the victim of a crime, not the criminal, as falsely alleged. No different than David pleading his case pre-trial, there was no acceptance of the credibility of our court, nor of the writ. This is proof of a lawlessness that pervades everything de facto. On July 24th, 2024 AD, 2 weeks later, 6 members of our Civilian Court of Record made a second trip to both locations to deliver, that is, serve, a writ of mandamus to the same parties for failure to respond appropriately to the writ of habeas corpus and to the veracity of our Article 3, Amendment 7 Civilian Court of Record, for which there is no appeal in fact. The only response we received from the Oregon Department of Corrections, ODOC, was an unsigned letter acknowledging our intention to return to serve documents. In the letter, we were, quote, hereby notified that the ODOC director, institution, superintendents, or any other staff member will not be made available to meet with you in person or by phone, end quote. In other words, it would be fruitless. Rather, we should mail, quote, any paperwork or service documents, end quote, to the provided address. The purpose of a writ of mandamus is an order by a court, that is us, to a lesser government official or officials to perform an act required by law, which they have refused or neglected to do, and it commands them to refrain from performing an act the law forbids them from doing. The keeper of the keys, that is the bailee for the building, and the jailer for the man, must be notified of this release. Your failure to produce our living, breathing, flesh, blood, mind, body, soul, spirit, man, has commenced this document and notice of intent to hold a grand jury from our jury pool with ensuing appropriate actions, notices, and, if a true bill, a petite jury trial will ensue. You have 7, 14, and 21 days to fulfill our demand for the release of David Anthony Coolidge to his proper jurisdiction, or you will have acquiesced and we will proceed by providing all of the evidence to our grand jury. Should the grand jury find David Coolidge worthy of a fair and just trial of his peers, their decision will result in a true bill which will commence a petite trial of David Coolidge. Additional grand and petite jury trials will commence convictions against Michael Reese, Ken Jeske, and Corey Fuhrer of the Department of Corrections and personnel, counsel, employees, agents, principals, and/or assigns to be named later for due process violations as per 18 U.S.C. 3571 in their contempt of common law, specifically non-compliance with our writ of habeas corpus ad subjudiendum and our writ of mandamus. In this document, we cite several laws from legal, guaranteed and disclaimers with full faith and credit, which we often refer to in our instruments. And then we add the DOJ as agent to the entity responsible for the enumerated requirements of Article 3, the one Supreme Court that must claim original jurisdiction to be a court, to be considered to have jurisdiction when found in conjunction with Amendment 7, Civilian Common Law Court of Record. The DOJ has failed miserably in their responsibility. This communique is not intended to mislead, defraud, deceive, or threaten in any way, and is submitted in good faith and with clean hands. We do lawful, not legal, and this is our best effort. We must do it ourselves. We define the words we use. We decide our method of communication. On Oregon, without the state of Oregon, aka State of Oregon, within the United States of America, the constitutional Republican form of government. Then there is a living testimony in the form of an affidavit of truth for our court clerk, Ron Broman. And then the jurat was signed by several of our members with thumbprint. And this was sent, as I said, to Mike Reese, Ken Jeske, and Corey Fuhrer, and a number of others in our Oregon state governance. Thank you.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.